I'm sorry, apologies. Good afternoon. It's been one of those days today. Good afternoon. I want to welcome all of you to the Senate Rules Committee. We have quite an agenda today, but we're going to try to be as efficient as possible. Want to make sure we get everyone's testimony, but again, I want to be as efficient as possible. I know we have a lot of folks with a lot of questions here today. Let's establish a quorum. Madam Secretary, please call the roll.
Senators Berryhill? Here. Berryhill here. Leyva? Here. Leyva here. Mitchell? Here. Mitchell here. Cannella? Here. Cannella here. DeLeon?
Here.
DeLeon here.
We've established a quorum. Why don't we go to file item number 1. Colleagues, we're going to skip over right now file item number 2. We're going to go to file item number 1, and then we'll go 3 through 7. 3 through 7. Can I get a motion? We have a motion made by Ms. Mitchell. Madam Secretary, please call the roll.
Senators Berryhill? Aye. Berryhill aye. Leyva? Aye. Leyva aye. Mitchell? Aye. Mitchell aye. Cannella? Aye. Cannella aye. DeLeon?
Aye.
DeLeon aye.
Motion passes 3 through 7 on a 5-0 vote. Thank you very much, colleagues. Let's go to file item number 2, which are the appointments before us, the governor's appointments. We will take on first the Agricultural Labor Relations Board, and that is Ms. Genevieve Shiroma. Ms. Genevieve Shiroma, please, welcome. Good afternoon.
Thank you.
Why don't we start off? Introduce yourself. Well, before you introduce yourself, actually, if there are any friends, family, or loved ones that you'd like to introduce, please do so. And then you can make a statement, and then we'll dive into it, okay?
All right. Thank you so much, Chairman. Yes, I do have several family members and some colleagues here. Very quickly, my husband, Michael Abbott, is here. My dad, David Takeo Shiroma, is here. My stepson, Damian Abbott, is here. Good friend, Petra Sullivan, is here. And my colleagues on the board, Chairman Bill Gould, and board member Catherine Rivera Hernandez, and the General Counsel, Julie Montgomery.
Okay, fantastic. Why don't we go into your statement, then we'll go to a Q&A or commentaries from the members.
Thank you so much. Good afternoon, Chairman DeLeon and members of the Rules Committee. I am deeply honored to appear before you today for consideration for confirmation. It has been a privilege to serve these past 17 years on the board. During this time, I've deliberated on many cases involving issues ranging from representation elections to bargaining issues, as well as cases involving employee concerted activity, jurisdictional questions, and remedial issues such as back pay and bargaining make-whole. In each case that comes before me, I consider the applicable law, what the administrative law judge has ruled, the findings of fact, and the arguments of the parties. In each case, looking to the Act and past case law, I deliberate with the rule of law as my guidepost. I made a point of attending agricultural economic seminars and conferences, seeing agricultural operations firsthand. Each time, I have renewed appreciation for the magnificent complexity and diversity of California agriculture and its people. If I am confirmed, I will build upon my years of experience and continue to apply the rule of law. I thank you for this opportunity and would be happy to answer any questions that you may have.
Thank you very much, Ms. Shiroma. Why don't we start with questions, commentaries from the members. We'll start with Mr. Berryhill.
I get to start it off, huh? Well, welcome. And thanks for coming by the office the other day. We had a good, frank conversation. I am going to rehash some of those questions just to get you on record. You bring quite a coalition of folks, both for and against you today. This was under all of our doors earlier today of opposition, for your confirmation today. But that being said, I've been here in the legislature for about 9 years, and even though I'm new on this Rules Committee, I don't think I've seen the opposition in my 9 years here that I've seen on your confirmation here today from the industry. Just thinking and claiming that they feel you're very biased. That being said, we had a very good conversation the other day, but the farmers I've talked with indicate they believe there's been a heavy bias against them and for the unions over the last 5 years. And a couple of the guys that I talked with said that they saw kind of a transformation. They thought that 5 years ago that you were willing to work with them on a regular basis, and since then, you've been very biased towards the union. So I guess, how do you answer that charge?
Senator, I assure you, as I've assured others who have watched this, my work, whether it's the last 5 years, the 133 published decisions that have my name to them, the administrative orders that I've worked on, over 270, reflect a rule of law, reflect a careful consideration. The nature of the work is that there's a screening that occurs, an administrative law judge conducts a hearing. Those decisions from the administrative law judge are appealed to the board. We deliberate. If someone is unhappy with our decision, they're appealed to the district courts of appeal. Our record, my record, is good. We have been affirmed in over 90% of those decisions. These past 5 years, I've kept an open door. I've been accessible. I've attended as many farmer and grower association activities as I could, took in tours of agricultural operations, and have always looked to be very clear as to why a ruling went this way or that way in those published decisions.
Yeah, thank you. Can you provide me with, or the board here, with specific examples of you and the board showing a balanced perspective? I mean, how many cases have you ruled with the farmers?
Over time, I don't have a specific number count for you, but let me give you some examples. And the reason why we don't go with percentages of this way or that way is because each case that comes before us is unique, different, but with the underlying foundation of the law based on the National Labor Relations Act and then our act. In recent years, there was a case where there was an election and the employer argued that there were workers who worked off-site, that they were agricultural workers. The union argued that they were not, and in evaluating the workers' status, we ruled that they were indeed agricultural workers and their ballots were opened. Okay? There was another case, which employee is a supervisor or is not a supervisor. There again, we had arguments on both sides, and that, by the way, is the way the board works. There are the judge's decision appealed to the board. There are arguments on all sides. We weigh everything. We rule. In that particular case, there were arguments as to whether or not specific employees were supervisors or not. We ruled, based on National Labor Relations Board case law, that they were not supervisors, therefore they were allowed to vote.
So you would argue that it's been a very balanced approach, because there's plenty out here that would disagree with that.
Yes, sir.
Okay, let's switch gears a little bit here, and I want to talk a little bit about Richie Ross and your relationship, your political relationship with him. In fact, he has been your paid consultant in your SMUD races throughout the years. Mr. Ross, as you know, is a registered lobbyist employed by the UFW and, in fact, lobbies the ALRB. Is this not a conflict of interest, in your opinion?
It is not. The campaign activities for my SMUD board are separate and do not overlap with my Agricultural Labor Relations Board activities. These are moments in time in terms of putting together a campaign flyer. These accusations, what have you, were lodged with the board through a case that has been before us, the Growan farming decertification case. These accusations were lodged by the decertification petitioner. And as we processed the decision, there again, based on longstanding practice of the administrative law judge ruling after many days of hearing, testimony, and so forth, that decision being appealed to the board, arguments on all sides, including this petition, and in analyzing that against the standards by which I am weighed, the evidence that was provided, the arguments made, the board concluded that that petition would be denied, that there was no conflict in terms of a financial interest on my part. I have not had a financial gain, and there was no evidence showing a bias reflected in the decisions. And the decisions are published. That Growen decision is also published. Those arguments that were made and the resolution of those arguments are contained in that published decision.
So you don't believe that you compromised your ability to be impartial by your relationship with Mr. Ross?
I am absolutely certain I'm not compromised. I am absolutely an honorable person, Senator.
Well, and I'm not saying that you aren't, but I am saying that the perception out there with your track record, certainly with the people that oppose you, they would have me believe that that you are influenced by Mr. Ross. And that line goes around the block, as you know, as I looked into this thing. Now that you brought up the Growen matter, when you had a chance to recuse yourself from that Growen matter, why didn't you do so?
Once again, the common theme here that I want to share is longstanding law, standards, case law. When these sorts of allegations are put forth to the board handles it within a decision. The standard, I know there's a standard that is cited in the opposition letter. It is not the correct standard. We are governed by Part 4.5, not Part 5. It is not unusual at all. In fact, it is longstanding practice that I would not recuse myself, that the board rules, and it's not uncommon. Well, for example, even our administrative law judges who have a different standard, but they themselves, if they are asked to recuse themselves, what have you, they rule. Okay? So it is a normal practice for the full board to deliberate and rule.
Well, you know, I just think that with your relationship with Mr. Ross, that the appearance of a conflict of interest is certainly there, and there's certainly folks out there that thought that you should have recused yourself on that vote. And I'm down to just a couple more questions. On the Growen matter, it's constitutionally, it's clear that all votes are cast by a voter shall be counted. Can you explain to me why the ballots have not been counted in that Growen case when it's a basic American right? And I will tell you before you answer that I have been to the Growen packing house and talked to many of those packers in there, and all they wanted, win, lose, or draw, they wanted those votes to be counted. And yet the board, in its ultimate wisdom, seemed to, I think they shredded the vote.
No, they are not shredded, Senator.
Oh, you still have them?
So
why, can you tell me why they shouldn't be counted?
Yes, certainly. Once again, based on longstanding procedures at the National Labor Relations Board and also with the Agricultural Labor Relations Board, when you have an election where there are charges filed in the lead up to the election that allege employer assistance to the decertification effort, the standard practice in our case law and in national case law is to hold the election, impound the ballots, and litigate after. And especially in the agricultural setting, when there's a 7-day election, There is the ending of the peak employment. These are all requirements for an election in the agricultural setting. Then the ballots are impounded by the procedures, which are contained, again, both nationally and with the LRB, and then litigate and then determine what was the outcome. In the Growan matter, we have a published decision, which is on appeal, okay? But our published decision, the final ruling of the board, is to affirm the judge. And the administrative law judge said that, in fact, there was employer assistance, which is not allowed in a decertification election when you have a certified union at the property.
But can you see why there are folks out there that cry bias when you've got literally thousands of workers that simply want their votes counted, and you've got, you know, one UFW person that says there's a conflict and you're going to hold the whole thing up over that? You can see why all of a sudden people say that this appears to be a very biased decision.
Senator, in labor relations with the Agricultural Labor Relations Act, that relationship between the certified union and the employer is established through case law. And as with the Growan case, when you have an employer who has provided assistance to the petitioner who is working to get rid of the union, that is a violation of the act. Meanwhile, it is up on appeal, and when a decision is up on appeal, the ballots are, there is a chain of custody, secure locked location, and nothing happens to those ballots till it is fully resolved. If we are sustained in the appeals court, then there is a record retention process for any records. So at this point, we are standing by to see what happens in the appeals court.
Okay, last question. The LRB, under your watch, spends almost 40% of its budget going after one farmer and its workers. And by all accounts, that union abandoned those workers 25 years ago. How can we justify spending so much taxpayer money to force them into a union contract that I'll tell you, the many that I talk to just simply don't want it?
So, Senator, I've seen those figures. I don't know where those numbers come from. The board continues to operate as it always has in terms of processing decisions. We do not have a backlog with our decisions. We are managing our caseload. The general counsel, activities in terms of complaints going forward, going to hearing. There are many, many different types of cases. So I haven't been able to verify those numbers. And I assure you, the case was dealt with in the same manner as we have dealt with all other cases that have come before the board.
Well, this seems just a little bit over the top to me. And I certainly, along with a lot of farming groups out there, have some concerns today, but I certainly wish you the best. And that's the end of my questions, Mr. Pro Tem.
Thank you very much, Mr. Berryhill. Ms. Leyva? Ms. Leyva.
Thank you, Mr. Pro Tem. Good afternoon, Ms. Sharoma. Thank you very much for being here. I do have a couple questions, but before that, I just want to make a couple comments. As someone who spent 20 years in the labor movement, either as the president of my union or the president of the California Labor Federation, it was my honor to represent working women and men. Now, I understand on the board, your position is a little different. You are unbiased, and you have to look at the law and make your decision accordingly. In looking at your record, I do not feel the way that others feel, that you have a bias. But I would also say if you do have a bias and it's toward workers, that's wonderful. No one has a bias towards workers. Usually it's the employers that come out smelling like a rose. And I just want to make a comment to my senator friend over here about you and Mr. Ross and your relationship in retaining him. I would just say that like-minded people stick together, that if I were going to work with someone or hire someone as a progressive Democrat, I probably wouldn't pick a conservative Republican to work with me. We might like each other, but probably our views are a little bit different. So I just wanted to make a couple comments before I ask you some questions. You've been on the board for 17 years. I know in my 20 years with the labor movement, some of the worst working conditions were for our farm workers up and down the state, the people who put food on our table. And I'm just wondering if conditions have gotten any better, if you've seen improvements in the 17 years that you've been on the board.
I think that the laws that have been adopted by the legislature provide a backdrop for conditions, whether it's heat or what have you. Overall, I would say this. The farm workers, and I know that there are farm workers here today, it is an amazing thing to see them at work. And I know all of us, no matter whether we're an employer, management, and I am in management. As a board member, I'm a manager. To see the farm workers out there, oftentimes with the farmers themselves, and what's also changed is some of the mechanization, which doesn't take the place of the farm worker, but provides for efficiencies, and I marvel. Because I go to the grocery store and I see the berries, the strawberries, the peaches, the broccoli, the cauliflower, and I've seen them harvested. And it is an amazing thing. I wish I could package up for my friends that when you go in the grocery store, all of that is handpicked, and the workforce is amazing. So I think, if anything, what I've seen over the years is frankly simply a greater efficiency, which is, I think, a good thing.
I would agree that efficiency is better, but my main concern is the workers. Do you think that the working conditions have gotten better for them?
I think the working conditions have gotten better. There are ancillary things such as housing, which is not in our purview, that needs some work. I think all would agree on that. But I think the conditions have gotten better.
Good. Well, that is a step in the right direction, and from my view, I do think, and it's not your job to do this, I think we have a long ways to go for our farmers. The board has been operating minus 2 positions. How has that hurt you trying to do your job and the caseload that you have to fill?
Honestly, I would have to say it has not hurt insofar as the board members that I serve with have all been very committed. One of the senators asked me what happens if somebody is sick or on vacation. That person comes off of vacation, gets on the phone with us. The person who is sick is on the phone with us to meet our deadlines. So we have been able to keep up with the workload and have been, and our published decisions are there as proof positive of getting the work done.
Very good, thank you. That's all I have for questions. I just make one more statement for the record, and that is in the case of Gerwin Industry, Mr. Gerwin, he is a billionaire, and I would wonder if he is supporting the farm worker overtime bill. I'm not asking you to answer that, but I would doubt that he is. So with that, Mr. Pro Tem, that's all I have.
That was a rhetorical question, or?
It was a rhetorical
an editorial
question.
right there. Okay.
More of an editorial,
So
yes.
we have it for the record. Why don't we go on to our vice chair, Mr. Canella,
Thank you, Mr. Pro Tem.
one of the greatest farmers we have in Ceres,
I have
California.
a small garden in my backyard. I do not employ any farm workers, just myself, so it's not doing well. A lot of questions have been asked, and I've enjoyed our meeting today, or not today, but a couple of weeks ago, but just a few follow-ups. As I recall in that meeting that you had with Senator Berryhill and I, he asked that question about the numbers and if you could show the metrics on the cases for the industry and for the farm workers. And you, I thought, committed at that time that you would get that information. Is that information not available?
It is available.
Okay.
Yes, because it's all based on our published decisions and our published administrative orders. We can certainly provide that to
Well,
you.
I think we were hopeful you would provide it by the meeting, so.
And the reason why I was cautious is because I don't want any kind of a impression that, that was some kind of a percentage, kind of a metric,
Yeah.
but rather that by the natural course of decisions coming before us, there are winners and losers. And in that array, there are times when the union loses, there's times when the employer loses, there are times when the individual farm workers lose as well. And on the reverse, there are times when each wins. And that is reflected in the array of decisions.
I understand that, but I hope you can understand from our perspective, if one side is always losing, then that would be a bias. And that's why we wanted to see what the metric was to show, because in our meeting, you assured us that you're fair and unbiased. And I don't think any of us really want any bias, right? Because if it's bias for one side, then the other commissioner could have bias for the other side. I want there to be no bias whatsoever. You judge every case on its merits and make a decision. So I think seeing how you've ruled over the past, I think would have been helpful. So it's unfortunate you don't have that, but it's fine, you don't have it. So on the conflict of interest, again, there's a legal conflict of interest, and then there's the kind of the appearance of a conflict of interest. And as I understand it, the complaint went to the board to say you had a conflict, and then you participated in just the vote to say whether you have a conflict. That seems unusual to me. I think I would have excused myself and say, look, here's what I think. I'm going to leave the room. You, rest of your board, you vote on it and make your decision, because it seems like you would have an influence on your fellow board members. So why wouldn't you? I understand why you ruled on the case, because the board said you don't have a conflict, but why wouldn't you just remove yourself from the vote on whether you had a conflict?
You know, based on past practice and how other boards have assessed that, other boards prior to my serving handle it in the same manner. And sitting judges themselves rule on petitions, what have you. So it is not unusual. And also, in terms of delving into the appearances and so forth, again, going by case law, longstanding standards and so forth. And I just wanted to say that, for example, in our board decision, we cite to the Morongo Band of Mission Indians, the Today's Fresh Start, and they stand for the proposition that under this legal standard, neither prior political affiliations, contributions, et cetera, nor speculation drawn from them establish evidence of actual bias, that you really need to look at those decisions and the rulings, and in looking at my rulings, they show that I have, and the board has relied on rule of law.
Yeah, but again, I'm not talking about you deciding on that actual case. I just think if I were in your place and someone came to me and said, look, we believe you have a conflict of interest, and I said, okay, let the rules body decide whether I have a conflict, I would not participate in that discussion, because I would think that it's like, look, I'm going to make my case and all of you make the decision. So I think the fact that you were involved in the decision on whether you had a conflict, I think that rubbed a lot of people the wrong way. And I think in the future, if that came, I think it would be better for all concerned if you just left the room. Here's why I don't think I have a conflict. I'm going to be out there. You guys decide whether I have a conflict of interest or not. That's the only point. I think people were concerned for that. So whatever. I don't think you broke the law or anything like that. But again, it's the appearance of a conflict of interest. So the other thing is the board, you guys haven't had a meeting since January, and the last published minutes of the board are from April of 2015. And again, there's this concern that the board is, well, you're up here today, maybe it's the board, but we'll just talk about you, that you're biased. You say that you're not, and okay, but when you're not even publishing minutes for over a year, there's not transparency, and so that makes them more and more concerned about what the board's doing. why can't you just get the minutes out? Just, you have a meeting, you make a decision, and the minutes get out.
Senator, we are subject to Bagley-Keene, the Open Meetings Act. From time to time, the chair will call a public meeting. Our work on cases are done through closed session. That is the procedure both at the national board and the state board. A board meeting last December, our next meeting is coming up on June 30. At the June 30, under Bagley-Keene, those minutes will be presented and we'll vote to approve them, and then they will be published.
Okay, so you had a public meeting in January
December
of 2000, December of 2016.
2015, yeah.
I'm sorry, of course, it's not 2016 December yet. December 2015 was your last public meeting, yet your last minutes are reflected are April of 2015. So why couldn't you have caught up on your minutes at your December meeting?